And does everyone, or can everyone see my slide now? Okay.
Yes, John.
Yeah, okay. So, good afternoon again, everyone. I think nabanggit ko nga kanina sa chat na medyo umuulan sa labas, so I became concerned na baka karoon ng issue sa video. So hopefully hindi naman, at least for the duration of our session today. Medyo limited ang time, so I'll dive straight into the topic that was assigned to me, which is more or less to provide insights as to the results of the data privacy audit that all of you supposedly participated in. But having seen the results, actually, I think I felt that it would be better for us all to spend some more time on discussing what is the privacy program or what is a privacy program, which is what that audit was supposed to measure or to assess insofar as your respective LGUs are concerned. Para habang mas naiintindihan natin kung ano itong privacy program, mas mapapadali din sa tingin ko yung trabaho ninyo in terms of how to go about establishing it for your respective LGUs. Okay. So, ganito yung magiging flow lang ng ating discussion. It's very short. So, I'll just define what a privacy program is. Briefly discuss ano yung models or templates na binigay so far ng National Privacy Commission up until this point. And then, ano naman yung alternative model na sinasuggest namin. Hindi naman siya hinugot lang sa ere. Anyway, nag-participate din naman ako mismo personally doon sa mga models na dinevelop ng National Privacy Commission. And then finally, after becoming familiar with all of these things, tingnan natin yung very short presentation on the audit results. Okay, so what is a privacy program? So maraming tawag dito, minsan data privacy compliance program. Ang NPC refers to it a privacy management program. The nomenclature or the name itself, hindi naman siya ganoon ka-importante or kahalaga. What is important is the substance. So kung ano ba talaga itong program na to na tinutukoy natin. In essence, siya yung totality ng mga protocols, processes, policies ng isang organization, including a local government unit, pagdating sa protection of personal data. So when we say protection of personal data, we're not just talking about confidentiality of personal data, which is one misconception that most people harbor. Nakakala nila, nakarinig nila yung term na data privacy, akala nila it's all about keeping information private or confidential pa nga. It's not. So even in instances where information, personal information is public or readily accessible to the public, it does not mean na walang data protection in play in relation to those types of information. So itong diagram or infographic na nakikita nyo, parang it's supposed to represent what a privacy program in essence looks like. So kung tatanggalin mo actually yung pinakagitna dyan, which is about personal data alone, the entire diagram would describe a data governance program. So you have and processes interacting, and then in their interaction, they relate to data ownership. Sino yung nagmamay-ari or at least pinaka-steward or custodian ng isang piece of data set? Ano ba yung information life cycle for a particular data set in terms of security then? How do we secure that data? How do we manage that data? How do we use and analyze that data? And all these different policies and procedures na pinag-uusapan natin. Now, considering all that, we carve out only those that relate to personal data or personal information. Yun yung privacy program. Yun nga. Tapos, it's a small part of what is generally considered as a data governance program. Yan. If we ask the NPC, And if you ask them regarding the establishment of a privacy program, na it's also sometimes called a privacy compliance program pala. Yung unang inintroduce sa atin ng National Privacy Commission is yung tinatawag nilang 5 pillars of compliance. If I'm not mistaken, the National Privacy Commission has already held 1 or 2 ang tawag nila DPO assemblies. May mga number pa nga yun 1, 2, 3, 4, parang gano'n. And then one of those assemblies are catered specifically to local government units. So I'm not sure if any one of you here were able to or was able to participate in those orientations ng National Privacy Commission. Hopefully, meron or lahat nga kayo kasi yun yung best venue actually for you to be introduced to the concept of data privacy and the Data Privacy Act itself. Kasi hindi natin kaya siyang i-discuss with the limited time that we have today. So ito yung 5 pillars na sinasabi ng NPC. Number 1 daw, have a data protection officer. 2, conduct a privacy impact assessment. And then yung 5th, yan yung having systems in place for managing data breaches and other types of security incidents. Yung 3 and 4th, 3rd and 4th rather, medyo para sa akin misplaced or hindi ganun kaganda yung pagkaka-design or pagkaka-develop nito kasi when you think about it, all of these things already put together would comprise the privacy management program. And I think the National Privacy Commission realized that. Kaya nga, after a few months, inintroduce naman nila itong tinatawag na compliance and accountability framework. So this time around, nag-divide sila ng specific categories, may relating to governance, risk assessment, etc., etc. And then, ito daw, when you put all these things together, then you will have your parang yung framework, and then one of them would include the privacy management program. Andyan siya sa number 4. So for me, this is an improvement from the 5 pillars, but still, it's still not enough or very helpful actually. Now speaking as a data protection officer, someone who is tasked to establish this and then implement and manage it for a specific organization. So what the NPC came up with next is a checklist. Now the checklist more or less represents yung elements ng framework doon sa previous slide. Except that, meron din silang ginalaw nila yung ibang elements, dinagdagan nila yung iba, and so on. For me, hindi pa rin mas helpful ulit in the sense na nagdagdag ng additional details. Pero overall, I think it's still not at that point or level kung saan ideal na siya, especially for data protection officers or for C-level, kumbaga, executives, in terms of adopting it and implementing it for their respective organizations. But if you want to look at these things, lahat naman to available sa website ng National Privacy Commission. Meron sila doon toolkit and even yung presentations nila, nilalagay naman nila doon. So you can download them to get a hold of these materials. So what we did, ako and then yung iba kong former colleagues from the National Privacy Commission was to simplify all these things. And then we came up with this alternative model composed only of 8 key components. And this is what we would suggest would or should comprise your privacy program. Don't worry, now in adopting this kasi sabihin nyo, iba yung sinasabi ng National Privacy Commission. Hindi naman wala dito, kumbaga, na wala doon sa pinopropose ng National Privacy Commission. What we did was simply to reorganize them in such a way na it would be easier for you, for your LGU, or kung mapunta ka man sa private sector, for your company or organization, to make it easier for you to implement, to establish a privacy program and implement it in your respective organization. So ito yung 8 components ng isang privacy program. Have a data protection unit, have a system for managing security incidents, have a system for conducting privacy impact assessments, have a system for establishing and maintaining transparency and consent mechanisms, having a system for managing your relationship with third parties, with data subjects, with the regulator, and finally, having all these different mechanisms in order to build the capacity of your organization, of your LGU, to comply not just with the Data Privacy Act, but with other data protection laws and regulations. So we'll briefly go over these 8 elements para makita nyo din what we mean by these 4 components. And try to recall na rin ano yung nandoon sa privacy program scanner na binigay sa inyo and sinagutan. Kasi ito din yon. So when you say, or when we say na kailangan ng isang specific organization, ng isang LGU ay kailangan meron siyang data protection unit, ang sinasabi is meron siya dapat, kasi nakalagay sa Data Privacy Act, personal information controller should have an individual or individuals in charge of ensuring the compliance of an organization with data protection laws and regulations. So ito yung data protection unit. Sometimes a single person may be enough for those small, very small organizations or businesses. But in most cases, one is not enough. Kaya nga nakalagay sa batas, an individual or individual. So yan yung data protection unit mo. When you say na meron ka nang na-establish ng data protection unit, ang some of the possible outputs na pwede mong ipakita to demonstrate your compliance for this specific requirement, yung meron ka na dapat isang data protection officer. Yung ibang organizations, yung ibang national government agencies, they have multiple data protection officers, which is fine. An alternative to having multiple data protection officers is you have one DPO and have a compliance officer for privacy or compliance officers for privacy. And then having a data protection office itself would be one of the outputs. Sa amin, sa Ateneo de Manila, meron kaming data protection office made up of 6 individuals. So yung staff complement ng data protection office ay 6. Meron isang parang group of companies na they share a single privacy office. Dito to sa Pilipinas, I'm speaking of a specific group of companies dito sa Pilipinas, ng kanilang privacy office is composed of around 40 individuals, which is different pa from the DPOs that are designated for of companies. So ganoon kadami yung, or kalaki yung kanilang data protection unit. Next, you should have, sabi ko kanina, a system for managing data breaches and other types of security incidents. Ang pinaka-output actually dito is for you to have a security incident management policy. This policy should embody most of the other outputs expected from this component of the privacy program, such as having your incident response team. Ito yung team or yung committee na in charge every time merong suspected data breach or security incident. Sa amin sa Ateneo, meron kaming 2 individuals dyan. Kung nire-report, sila yung nag-iimbestiga or tumitingin doon sa specific incidents na yun. And then magre-recommend kung anong gagawin doon sa incident na yun. Including a recommendation whether that particular type of data breach, let's say it's a data breach, needs to be reported to the National Privacy Commission and to the affected data subjects. So lahat ng mga yan will make up your security incident management system system that make up or that is one of the components of your privacy program. Next. You should also have a privacy component. Itong PIA, in a nutshell, siya yung paraan nyo to determine ano-ano ba yung vulnerabilities na meron ang inyong organization. Specifically, yung mga data processing systems of your organizations. You surface those vulnerabilities, you surface the threats, and you come up with all these different privacy, so-called privacy risks that you are exposed to. And then you decide how you want to manage those risks. Accept them, minimize them, or remove them completely, etc., etc. So parang yung typical risk assessment process natin, except that this one relates specifically to data protection or data privacy. So one of the outputs that is expected for a PIA system is having a personal data inventory. Ideally, you have an inventory for your entire organization. So you have your different systems, and then for each system, each project that involves processing personal data, you have your data inventory. When you say data inventory, ano-ano yung mga personal data na kinokolekta or for each of those data sets, you also have to have a map of your personal data flow or information flow. Pag sinabi nating information flow or data flow, we're talking about the journey, more or less, that data goes through from collection or generation to use to sharing all the way up to deletion or disposal. So dapat kapag tinanong kayo, anong ginagawa niyo dito sa information na to na kinokolekta nyo, let's say for hiring purposes, hanggang sa point na i-dispose or i-delete nyo na yan, that would yung information or yung okay. Ay, sorry. Ano nangyari? Sorry. Hold on. Ayun. Okay, and then the last one other component or part of your PIA system is for you to have your privacy impact assessment team. This would usually be made up of your data protection unit along with representatives from all these different offices or units that are involved in this particular data processing system or project. So yung PIA team, the more stakeholders na nagpa-participate dyan or are involved in the team, the better para may different perspectives in terms of assessing the risks of the specific system na sinasubject nyo sa privacy impact assessment. Okay. Next. Yung transparency and consent mechanisms. So I think by now familiar na kayo doon sa term na privacy policy or privacy notice. So that is one transparency mechanism. So isa kasi yung transparency sa key or basic principles pagdating sa data privacy. When you say transparent yung data processing mo, dapat alam ng mga tao na kinokolekta nyo at ginagamit nyo pala yung kanilang personal data. Parang walang pagpaprocess na patago, especially if yung processing na yun will involve a decision-making component involving the data subject or the individual. So you should have transparency mechanisms which is usually through privacy notices or privacy policies. Later on, as we go through doon sa results nga ng audit, we will see nga na almost none of you have a privacy, even a simple privacy notice, even in relation to just your website, for instance. Only one answered yes for that particular question. So every organization that processes personal data should have mechanisms through which alam dapat ng tao kung ano yung information nila ang pinaprocess nitong organization na to or ng LGU na to, ano ang ginagawa nila dyan, kanino yan sinishare, gaano katagal yan nire-retain, and so on and so forth. All this information na kailangan yung ipaabot sa mga tao, nandoon yan naman sa batas. Pag tinignan niyo yung right to be informed ng so-called data subjects, kung ano yung mga information doon na dapat parang kailangan yung ibigay outright or sabihin outright even without being prompted or asked, yun yung kailangan for transparency purposes. Yung consent mechanisms naman, this is critical for those instances na ang legal basis mo for processing personal data is consent, the consent of an individual. Tandaan natin na when we talk about data privacy, hindi naman lagi na every time gusto mong i-process ang personal data ng isang tao, ng isang individual, kailangan mo laging magpaalam or humingi ng consent. That's also one misconception that arose when people suddenly realize na meron na pala tayong Data Privacy Act, na meron na palang data privacy. So maraming nag-aakala na. Also starting now, kung gusto nating mag-process ng personal data, kailangan nating magpaalam each and every single time, which is not true. There are other grounds found in the law for processing personal data, and any one of them can be utilized in the manner na prescribed ng batas. So, going back, if consent ang magiging mong legal basis, then obviously you have to have this mechanism for obtaining consent. Tandaan natin din na according sa batas, ang consent has to be either written, recorded, or electronic. So, ibig sabihin, hindi pwedeng verbal consent lang na hindi mo nire-record. So, pag let's say over the phone ang collection mo ng data, let's say doon sa mga delivery services or yung mga usual na ginagawa ng mga BPO companies, for instance, in many cases, yung data collection nila over the phone. So kung hihingi man sila ng consent, over the phone. Ngayon, kailangan nilang i-record yon because if consent yung magiging nilang legal basis, kailangan recorded siya. Otherwise, kung hindi mo i-record, wala kang proof na nagbigay ng consent yung individual, then you will not be able to say nga na you have consent as the legal basis for your data processing. So yan, yung possible outputs dito nga is privacy notices or statements or policies. Nag-iiba-iba din yung tawag sa kanya depende kung saang bansa or saang territory and kung ano yung batas na pinag-uusapan natin. And then the consent forms and then confidentiality notices, kung makikita nyo, yung mga usually ito yung mga nasa emails, footer ng emails na kapag nakatanggap ka, nakalagay doon na if you're not the intended recipient, parang notify the sender and then delete it, etc., etc. So that's a confidentiality notice. It's also one type of transparency mechanism that you can adopt or impose. And then you have third-party management system. Under the principle of accountability, which is also integral in data privacy, ang isang personal information controller, including a local government unit, it will be responsible for the personal data it controls or is under its custody, including those it transfers or shares with a third party, whether that third party is a personal information processor, a service provider, or maybe a fellow LGU or a national government agency or a civil society organization for that matter, functioning as another personal information controller. So kung ikaw yung pinaka-custodian ng personal data, you will still be responsible for that information that you share, transfer, or disclose. And because of that, you have to manage your relationship with these third parties properly. Usually, you do that by having appropriate contracts covering your transactions, your data sharing or transfer with these other organizations. So if it's a data sharing arrangement, so between one controller and another controller, the recommended contract is a data sharing agreement. Previously, it was mandatory for government entities, but because of this new circular the NPC came up with in late 2020, optional na lang yung DSA, but it is still recommended and considered best practice according mismo sa National Privacy Commission. Ang sabi ng NPC, hindi na siya mandatory but you still have to make sure na your data sharing is covered by one of the grounds found in the Data Privacy Act. So kung walang ground doon, hindi mo pwedeng ma-justify yung data sharing mo. And at the same time, dapat you have to find some other way to make sure na secure yung data na sinishare mo doon sa other parties. Dahil nga hindi ka na pwedeng mag-rely sa contract, find some other way. Kung wala kang mahanap na ibang paraan, then might as well execute pa rin a data sharing agreement. Yung data processing outsourcing agreement naman, that's in relation to your service providers usually. So if you ask another entity, whether it's an individual or a company or an organization to process personal data for or on your behalf, it is actually required to have a data processing outsourcing agreement. Yung iba tawag sa kanya data processing agreement lang, subcontracting agreement. Again, the name itself is not important. What's important is what's contained in that contract. If it's a contract like this one, a data processing outsourcing agreement, nakalagay sa implementing rules ng Data Privacy Act kung ano yung specific provisions na kailangan makikita doon sa contract na yon. You can add to those provisions basta yung basic na listahan na nandoon of provisions are found there. So yun yung key dyan. Yung data protection questionnaire is actually, ang example niyan is yung privacy program scanner na sinagutan nyo. So this one, it is now fast becoming a common practice for companies, especially those based in the EU, na papasagutin na nila yung kanilang makaka-transact or makakatrabaho mga service provider. Na before nila i-engage yung service provider na yon, aalamin nila kung kumusta ba ang privacy program nitong bibigyan nila more or less ng information or i-allow nilang mag-process ng information for them. Kung hindi okay, then they will likely choose another service provider. So yan yung ibig sabihin natin ng data protection questionnaire. Iba-iba na rin na binibigyan na rin lang siya ng iba-ibang names ng other companies, other organizations. Kung gumawa man kayo ng similar doon, you are free to call it whatever you want. Basta yung essence niya is the same. It's a means for assessing the maturity of the privacy program of this third party na either you intend to engage or maybe matagal mo na siyang katrabaho and gusto mo lang i-check ngayon kung kumusta ba yung kanyang privacy program. Next, data subject engagement. In a way, simple lang ito. Kasi under the law, under the law, every individual whose personal data is being processed has a set of rights. Right to be informed, right to rectification, right to deletion, right to data portability, etc. etc. So itong mga rights na to, pwede nilang supposedly i-exercise and then i-assert against those companies, those organizations processing their personal data. So posibleng kayo yun as local government units. Ngayon, may mga exemptions din naman yun. May mga instances na may specific basis lang kung kailan pwedeng i-exercise yun. So in order to manage all these things, then you have to have a system also for addressing nga yung mga instances na i-exercise ng data subjects ang kanilang rights. Ang madalas ditong exercise na rights is of course access to their personal data. Meron kang individual, sasabihin sa iyo, pwede bang makita ko kung ano yung lahat ng information na kinokolekta mo sa akin. In some cases, or in most cases, companies will wait for the individual to ask for that information. Para naman sa mga mayayamang companies, let's say tulad ng Google, usually mga tech companies yan, Google, Facebook, Twitter, etc. etc. Gumawa na sila ng sistema para automated na. Pwedeng ikaw na mismo ang, kung gusto mong makakuha ng copy ng inyong personal data, meron ka na lang mga pipindutin na buttons and i-click na options from Google itself, from Facebook, the platform itself, and then pwede mo nang i-download yung personal data na hawak-hawak nila about you. Pero that is still a manifestation of your exercise of your right to access to your information, and then manifestation din siya of these companies recognizing your right and then upholding your right. Kumbaga, binigay na nila sa atin as individuals yung susi, kumbaga. Sinabi niya, gusto mo yung information mo, ito yung, dito mo siya makukuha. Parang ganun. Pero for most companies, most organizations, di pa nila yan kaya. So case-to-case basis na lang. So may pagka FOI ang format niya. Except that this one is only limited to you asking for your information, not information about other people. Ayan. What else? So yung mga forms dito or outputs rather, inquiry processing policy, obviously, kung gusto nilang magtanong about what are you doing with their personal data, Yun nga, yung sinabi ko kanina, like, how long do you keep them? Who gets to access my personal data? Then you have to have a policy covering those types of situations. Yung data subject access request, as the name itself suggests, yun naman, every time na gustong mag-access yung individual ng kanyang personal data, then you have to have a system also for that. Of course, you have to make a determination din kung ito ba talagang humihingi ng information na to tungkol kay Mr. X, ay si Mr. X. Or kung hindi naman, authorized representative talaga ni Mr. X. Parang gano'n. What else? And then a schedule for data protection-related offenses or violations simply because one of the rights also of a data subject is to complain. And then if they can complain, then it has to be clear to for your organization. Ano ba yung mga offenses as far as your LGU is concerned na pwedeng gawing or ireklamo or gamitin ng isang data subject against dito specific LGU personnel na supposedly violate ng data privacy or ng isang specific data privacy policy within your context or for your particular context. So yan yung data subject engagement. Regulator engagement, ito naman lahat ng pakikitungo natin sa regulator, which is the National Privacy Commission. Marami kasing paraan kung kailan meron tayong interactions with the LGU, with the NPC rather. Andyan yung pag-register ng ating data processing systems na for now though, suspended pa siya muna ng NPC habang inaayos niya daw yung registration system niya. Meron din tayong mga pagkakataon na pwede tayong humingi ng advisory opinion from the NPC. Meron ding instances kung saan required tayo actually on an annual basis to submit an annual security incident report, a summary of all the data breaches and security incidents that we experience for a particular calendar year. Meron ding instances when we are required to notify the NPC kung meron tayong automated decision-making process. So itong during the pandemic, for instance, there was a time na na-confront ko to as a data protection officer if we needed to notify the NPC kasi nauso nitong at least for 2020 to 2021 dahil walang mga entrance exam, di ba? Yung mga schools nag-adapt sila ng a different system for determining sino yung tatanggapin for that particular school year without relying on the entrance exam kasi nga walang entrance exam. So, yung mga schools nag-develop sila ng mga system evaluating yung mga nire-require nilang submissions from all applicants, whether it's not just grades from their high school grades rather, pero meron ding iba pang mga submissions and then these are all processed and then supposedly the school gets to determine yun nga, who gets in and who doesn't. So I had to ask na, is it automatic na you put them into this system and then out comes the decision already na ito si Mr. X tanggap ito si Miss Y tanggap din siya, pero si Mr. Z hindi, etc. Hindi naman daw. There is still human intervention. Meron lang component na parang automated yung processing, pero the decision making itself, meron pa ring human component. And therefore, wala pa tayong tinatawag na automated decision-making process. Kasi kung meron, that one has to be notified to the NPC. So that's again, one example wherein meron tayong relationship with the regulator. So all these things, dapat alam ng inyong organization how to go about doing that. Yun pala, yung compliance checks din ng NPC, meron silang specific circular for that. So ano yung gagawin nyo? Sino ang in charge dyan, etc. etc. So all these things, put them together, yan yung mag-make up nitong component na to ng inyong privacy program. And then finally, you have your capacity building mechanisms, all the things nga sabi ko kanina that will help your organization and your personnel comply with the law and other data privacy regulations, yung mga circulars ng NPC and so on. Ang isang example dyan is for you to have a privacy manual, which I think will be discussed later, for you to have data protection or data privacy trainings, whether it's internal or you attend external trainings being provided, not just by the NPC, but a number of service providers these days. and then engaging even third-party consultants for your data protection needs. So marami din, umusbong din siya as an industry these past couple of years. So all these 8 make up your privacy program. And as I mentioned earlier, if you put up all 8, then you have a privacy program, and then you put them against the 5 pillars of the NPC, you will be able to meet those 5 pillars. If you put them up against the compliance and accountability framework ng NPC, you will be able to meet all those things na contained there, as well as yung nasa checklist ng NPC. So ang ginawa lang nga, to reiterate again, is to make it easier for you to make sense of all those things na nilista ng NPC and of all these things na nire-require sa atin ng DPA, ng kanyang IRR, and all these different circulars ng NPC. Okay. Now, for the audit results. Sabi ko nga, when I went over it, excited pa man din akong tingnan sana yung results kasi multiple LGUs. But then, ang nirealize ko, very kung maturity ang pag-uusapan natin, masyado pang hilaw kumbaga yung inyong privacy programs. In summary, wala sa inyo actually may privacy program pa today. 2021, which is what? 5 years since nagkaroon ng implementing rules ang Data Privacy Act. And then almost 10 years na since the Data Privacy Act, which was passed in 2012. Meron actually sa inyong sumagot na yes, meron silang privacy program, but then yung mga sagot niya doon sa mga susunod na tanong, which is yun yung pinaka bare minimum nga for you to be able to say na may privacy program, puro naman no. So ito actually yung mga bare minimum na yun, yung mga susunod. So nag-yes na yes, we have a privacy program, but we don't have a DPO, we don't have an SIMP, wala kaming privacy notice, etc., etc. So actually, we'd have to count that also as a no. So baka na-confuse lang kung ano yung ibig sabihin nga ng privacy program. So no one has a privacy program. Itong DPO, ito yung marami-rami at least nagsabi na meron kayong DPO. 8 yung nagsumagot na meron daw silang data protection officer, which is good. 6 ang nagsabing wala. Ang issue lang, although at this point, parang pwede na siyang i-assume na lang or tanggapin na lang yung risk. Ang issue lang is, meron sa kanila, doon sa mga DPOs, nang ino-occupy na roles ay potentially pwedeng mag-give rise to conflict of interest scenarios. Baka nandito ang ilan sa inyo doon. Kasi ang na-identify ko doon, so meron sa inyong DPO na part ng legal, and then IT, and then HR. I would have to say na most people who are introduced to data privacy, instinctively actually, ang una din talaga nilang iisipin na gawing DPO is yung mga taong, or at least coming from those offices, that handle a lot of personal data on a regular basis. Kasi parang isipin nila, so tungkol pala to sa personal data, dapat kung may DPO tayo, galing doon, let's say HR, maraming data na hinahawakan ng HR dahil siyang in charge sa personal data ng lahat ng empleyado ng isang organization, di ba? Pero actually, kabaliktaran. Precisely because sila yung nag-handle noon, as much as possible, hindi sila yung gagawin mo dapat na DPO. Kasi kung magkaroon man ng data breach or security incident or violation ng Data Privacy Act, coming from this office, sila din, dahil sila yung nag-handle ng napakaraming personal data, ang risk din na magkakaroon sila ng privacy violation or ng data breach, mas mataas din sa kanila. So, ang likelihood mas mataas. So, kung nandoon yung likelihood, nandoon yung risk, at doon din manggagaling yung data protection officer, pag nagkaroon ng data breach, magiging conflicted yung DPO. Parang, anong gagawin ko dito? If I investigate it as a DPO, I will be doing my job as a DPO, but it will make me look bad as head of HR. On the other hand, if I keep it hidden or hindi ko siya asikasuhin or hindi malalaman ng iba, baka ma-maintain ko yung image ko as okay na HR head, pero hindi ko gagawin yung trabaho ko as a data protection officer. Nangyari na siya sa isang government agency in the past. I think it was around 4 years ago. Nag-consult lang yung kaibigan ko na who happens to be an official of that government agency. Na ang ginawa kasi nila, ang kanilang data protection officer is yung kanilang MIS head at yung IT head na rin nila. Parang ganon. So nagkaroon ng data breach. Yung website nila exposed pala yung mga sinasubmit ng mga tao na government-issued IDs nila. So kung nag-submit ka doon ng passport, ewan ko kung ano yung transaction, kung bakit kailangan nila mag-submit noon, na-expose. So ang daming mga tao na ang mga government-issued IDs nila ay na-access or nakikita ng the rest of the world. Ngayon, hindi yun ni-report ng kanilang IT head, even if may nagsabi na, nagsumbong sa kanila. Ang ginawa niya is tinago niya. Nalaman na lang ng management by accident na may ganun kasi may pinapahanap sila sa mga emails doon sa isa sa mga staff noong DPO and slash IT head, and then by accident nakita yung email na yon na sinusumbong nga doon sa IT head na may data breach kayo, etc. etc. So it would have been avoided kung hindi yung IT head yung kanilang data protection officer. So yan yung same reason kung bakit ideally hindi dapat yung HR, hindi dapat yung taga-IT. And then yung sa legal naman, dapat kasi the DPO can disagree with management. Kasi ang DPO naman will just have to give advice or recommend. The decision-making authority still remains with management, with the LGU, with the mayor, o kung may mga instances na yung sanggunian ang mag-make ng decision. So those powers, those authority, or that authority still remains with them. So the DPO will just recommend. So pwede siyang mag-disagree. Ngayon, if your DPO is also your legal officer, and then kayo yung management, you want to disagree with your DPO, and then you have to have parang legal support or some type of legal basis to support your position kung bakit ka magdi-disagree with your DPO. But if your DPO is already your legal officer, so saan ka ngayon kukuha ng legal support, di ba? So yan din, ideally kung bakit hindi ang legal ang gagawin mong DPO. That being said, tulad nga ng sabi ko kanina, I think it's understandable then why some people have no choice, or some organizations have no choice but to appoint or designate people already occupying certain roles. Even to the extent na baka nga may conflict of interest. Baka kasi yun yung mas trustworthy sa kanila, or talagang wala nang iba na pwedeng na-qualified to assume that role. Dapat ang solution sana dito was the National Privacy Commission talking to DBM and then CSC para magkaroon na talaga ng specific position sa government na ang tawag ay Data Protection Officer and then Compliance Officer for Privacy. Para pwede na mag-propose ng budget ng national government agencies or mag-allocate ng budget for these types of plantilla positions. Pero since 2016, mukhang wala pang nangyayari doon. So ang for now, yung mga nasa private sector lang nakaka-afford na mag-create ng positions na specific to data protection lang talaga. So yon. What else? Yon, wala rin sa inyong may security incident management policy. So I suppose ibig sabihin pag nagkaroon kayo ng data breach, kung sino-sino lang ang pwedeng ituro para magsabing ikaw mag-handle niyan, or ikaw yung umasikaso niyan, or worse, pabayaan na lang yan kasi walang mag-handle niyan, parang gano'n. May isa lang na nagsabing merong privacy notice, pero pag tiningnan mo yung privacy notice, it's just referring to the data collection or data processing when you visit that LGUs website, which is also okay. Pero ang hinahanap sana nating privacy notice is, in general, yung data processing na ginagawa ng isang organization or ng isang LGU. Now, obviously, marami kayong data processing systems, di ba? So it's either you have one big general privacy notice na kino-cover yung iba-ibang systems na yun, or you have specific privacy notices for each of those, at least yung major data processing systems nyo. Either way, pwede naman. Pwede din namang wala sila sa website. Ang importante is kung sino man yung intended reader ay mababasa nila or maipapaabot sa kanila yung information. Pero yung sagot nyo is, yun nga, wala. Wala kayong privacy notice, wala kayong privacy policy. Wala din kayong protocols for managing third-party engagements. May isa na nagsabi na meron silang privacy impact assessment. Hopefully, it's a good one. Kasi yan yung talagang magiging starting point for your privacy program, ideally. You perform a privacy impact assessment, and then kung ano yung mga vulnerabilities, ano yung mga strengths ng inyong organization, then you build on that para makagawa ka ng maayos na privacy program. And then even yun nga, an information security program, which is supposed to be complementary na nga lang for your privacy program, wala din daw. So given this, so hindi na natin kailangan isa-isahin yung mga elements kasi most of those naman ay no. Ang next na actually ata na may pinakamarami sa inyong nagsabi na yes, you do this, is yung nagsabi na you require personnel to attend trainings. I think 6 said na yes, you require people to attend trainings. So, which is also good, pero sana man lang kahit requirement na lang na magpa-train, di ba? Dapat sana 100% na para lang you have that basic knowledge about data privacy or data protection. Pero yun, 6 lang yung nagsabi na meron kayong ganun. So, recommendations. Obviously, number 1 would have to be have your data protection officer as soon as possible. Ideally, yun nga, try not to appoint someone or designate someone na could face a conflict of interest scenario in the future. Pero kung wala talagang choice, it's fine. Parang just akuin nyo na lang yung risk. Sana minimal lang and sana nga mapagkakatiwalaan yung taong involved dyan. And then as much as possible, don't give that person a lot of other concurrent duties or functions. Kasi napakalaking trabaho na yung pagiging data protection officer. Kung siseryosohin ng tao talaga yung trabaho niya. Next, as far as trainings are concerned, yung cost ng training ngayon is wala pang talagang standard eh. May makikita kang mura, may makikita kang mahal. For government, since government naman ang pinag-usapan natin dito, may recommendation is request from the NPC to provide at least their DPO-ACE1 training program. Ito naman kasi, itong responsibility na to provide training to government entities, including LGUs, inako pa rin naman ng National Privacy Commission. In-outsource na or may in-accredit na ang NPC for the training of non-government entities for the private sector. Pero for government daw, sila pa rin. So, humingi na lang sa kanila, libre pa. Second, establish a project team that will help build your privacy program. Don't take it as just one big project na kailangan nyo agad gawin all at the same time. Kasi that will be a recipe for disaster. So, ang gawin nyo is kunin nyo yung mga parang pinakamadali na ma-achieve in terms of time and resources na kailangan nyo na ibuhos doon. Let's say, drafting a privacy notice or privacy policy for the data processing your LGU is engaged in. So yun, low-hanging fruit yun. Sunod siguro sa having a data protection officer. And then have draft a security incident management policy. Siguro someone from legal, someone from IT could sit down and look at and come up with a security incident management policy. Yung toolkit naman ng National Privacy Commission na nasa kanilang website would be helpful in drafting this one as an SIMP. What else? Yung privacy manual, this I would probably say na ideally ito sana yung last kasi it would make up or it would include all those things put together. Pero meron ding template na ginawang NPC sa kanilang website and I think later nga may i-discuss din. So you can use that as a starting point. Ang reminder ko lang is don't just stop pagdating doon sa mga basic content ng isang privacy manual. Make sure na it contains a portion na discussing all those common issues that you confront as an LGU. Kami as an educational institution, kung ano man yung nature ng business or operations nyo, and then whatever industry or sector you belong to, dapat meron sana doon sa manual nyo taking up those common issues. Kasi that will make the manual really useful for your personnel. And then obviously come up with a privacy impact assessment. Even if baseline lang, yung sobrang basic lang yan, walang standard or prescribed parang methodology ang NPC, but the NPC has an advisory discussing ano yung basic na dapat nilalaman ng isang privacy impact assessment. So go look for that. I think it's advisory 2017-03, if I'm not mistaken. Establish a third-party management system. So yung at least man lang meron kayong template for data sharing agreements, outsourcing agreements, and so on. And then finally, document kung ano yung security measures na meron kayo as of now. I'm sure meron naman yan. Protecting data in general. So they would also protect personal data na rin. So include all those things in your documentation, in your inventory of your security measures. So yun lang muna. Let's proceed lang siguro sa Q&A. Apart from those na prepared na or na collate na, you may also have questions of your own based on what I've shown you this afternoon. So yan muna po.
Okay. Maraming salamat, Jam. Maraming sinabi si Jam. I will not try to summarize this because the time is better used for the question and answer. So, but one of the very big things na sinabi ni Jam ay yung data privacy is the totality of processes and policies of government on protection of personal data. So, napaka-importante yan, pero wag lang malito, it is but a small part of an entire data governance program. So, hindi lang data privacy ang data governance, but though it's quite important. The other thing is yung huli, yung dun sa data privacy checklist kumbaga na ginawa ni Jam, medyo nahuhuli ang ating mga project partners, ang lahat ng LGUs dito. But don't worry, I think it's not as if kayo yung putot sa lahat. I think it's a common thing across LGUs in the country. So similar to the rapid data assessment that we did for the project sites, nandoon sa medyo sa mga mababa pa, the first 2 steps pa lang. But that only means to show that there's no way to go but up. Right, so there's a lot of room for improvement, and projects like COLLABDev and PH3D are here precisely to help you deal with these issues. So, i-request ko lang ulit before we go to our question and answer. Please rename yourselves, yung inyong institution or affiliation, and then your designation and your names, kasi hindi namin ma-identify lahat pag hindi kayo nakaganyan. But we would like to thank the LGUs who are represented here. We have Irusin, Dunsol, and the provincial government of Sorsogon. We also have Borongan City, Arteche, and Giwan from Eastern Samar. We have Inupacan from Leyte. Of course, we have CDO here, and Palimbang from Sultan Kudarat. So maraming salamat po for joining us this afternoon. So now we go to the question and answer. We have initial questions that were submitted to us ahead of time, but after having heard si Jam, I'm sure meron kayong mga questions kasi iba yung tenor ng mga questions na una namin natanggap, at kung makikita nyo dun sa mga na-discuss ni Jam. May habol daw. LGU Salcedo is also here, and LGU Pilar. So thank you very much. Papalit na lang po ng pangalan para ma-identify namin kayo. Okay. So ito, yung mga bagong questions nyo po, please type them in sa Zoom chat box. But right now, I will read some of the questions that were sent in ahead of time. So ito yun, Jam, una from our G1 partners. How do you balance data privacy with freedom of information? What are the boundaries or limits of free flow of information?
Okay. Actually, yung question na to, very broad. Parang pwede ako magsulat ng isang buong paper discussing itong sagot dito. No? Pero siguro I would start with emphasizing na both the right to privacy and then more specifically data privacy and freedom of information, they're actually the same in the sense na they are both meant to benefit the public, individuals, kumbaga. Why? Because data privacy is, especially if we're talking about personal data that we have that's in possession of government, data privacy is supposed to protect those information habang hawak sila ng government. And then at the same time, ang freedom of information is as individuals, as members of the public, it gives us supposedly access to information na in the hands of government. And when we say naman information in the hands of government, hindi lang naman puro personal data ang hawak-hawak ng government, di ba? In fact, it's just a small segment of this entire range of data sets na hawak-hawak ng government. Na wala namang kinalaman sa yung iba diyan, wala namang kinalaman sa personal data. Now, ideally, the freedom of information or the right to information for that matter would cover all those things. So meron lang silang tiny part kung saan sila nag-overlap. And that is when you talk about personal data, especially personal data of other individuals. Kasi if we're talking about personal data mo as an individual, let's say, tulad nung nabanggit ko nga kanina, every individual or a data subject has the right to access his or her own personal data na hawak-hawak ng isang entity. So let's say it's a government entity. When you ask for a copy or access to your personal data, it's actually no different from you exercising an FOI, except that yung information na gusto mong hingin is in relation to you. So even nga yung pag-access ng information in that particular example, complementary both yung data privacy and yung or data protection and yung FOI. Nagkakaroon lang ng issue kung ang hinihingi mo ng personal data ay personal data na ng ibang tao. Now, absolutely prohibited ba ng data privacy or data protection laws ang paghingi ng information, personal data about other individuals? Hindi naman. Sabi ko nga, disclosure kasi, sharing or transfer of personal data is considered processing of personal data. And according to the Data Privacy Act and other data protection laws, pwede yan for as long as it is based on any of the grounds or legal basis that's found in the law, specifically Section 12 and then Section 13 of the law. And then in the rare instances na pwede rin siyang mag-fall under the exemptions found in the law, which is I think in Section 4, if I'm not mistaken. So yun, parang una, you balance that by simply looking at, I would recommend na wag mo nang tingnan sila as parang antagonistic ang relationship in relation to each other. Ako ang tingin ko sa kanila, complementary sila. In fact, when the EFOI was launched in 2016, kasama, magka-partner actually yung National Privacy Commission and then yung PCOO sa pag-orient ng mga different government or agencies pagdating sa pag-implement ng FOI while ensuring their data privacy is upheld. Parang ganon. Magkakilala din kasi kami ni Asik Ablan dahil magkasabay kami nag-aral sa University of Auckland. So, pero maliban doon sa personal na pagkakakilala lang namin, yun nga, ang emphasis nun is they are not supposed to clash, kumbaga. There will be instances na you will have to make a decision which one you are going to uphold, yung data privacy component or yung freedom of information component. But those are supposed to be rarer than most of us think, parang ganon. And then, in the same sense na yung data protection naman, it protects personal data, but there are instances where disclosure is allowed. Ganon din naman sa freedom of information, di ba? Na ang general rule naman dyan is you should be able to access information in the possession of government unless it's one of those exceptions na recognized by law. In this case, by the EO, and then yung listahan na kinamap noong interagency ata na nag-develop ng list of exemptions. So yun. Yung second part lang ng question, which is what are the boundaries or limits sa free flow of information, then I would say law, and then if we're talking about the Data Privacy Act, yung data privacy principles. So law in the sense na the law would usually say kung ano yung pwedeng i-disclose, ano yung pwedeng hindi. Kung pwede man siyang i-disclose, kanino siya or sino lang yung pwedeng mag-access, parang ganon. So that's one thing, that's one boundary or that's one limit. The second is yung tinatawag nating data privacy principles. Dahil nga, tulad ng sabi ko rin kanina, just because information is accessible or can be disclosed, that does not mean na parang free for all na. Pwede mo nang gawin kung anong gusto mong gawin doon sa personal data. Hindi rin yun totoo. Kasi one of the key principles din, for instance, sa data privacy is proportionality. So ibig sabihin, if you ask for information because you have a specific purpose in mind, yung hinihingan mo ng information is only duty-bound to release information na that's necessary for that purpose na you identified. So hindi pwedeng siyang mag-release ng karagdagang information na wala nang kinalaman doon sa in-identify mong purpose. And then conversely, wala ka ring right na humingi ng information na wala ring kinalaman doon sa sinasabi mong paggagamitan mo sa kanya. So that's one instance kung saan nag-ooperate yung data privacy principles. Marami yan. Collection limitation, purpose limitation, yung sinabi ko, data minimization, and then even yung storage or retention limitation na sinasabi rin, which is also a key data privacy principle. Kapag na-access mo na yung personal information, nasa sayo na siya, how long do you have the power or authority to keep it? Kailangan mo ba siyang i-delete agad-agad once natapos na yung use? That is actually the general rule. Or pwede mo ba siyang i-retain for a longer period, etc., etc. So yun, yan yung sagot ko sa second question. First limit would be the law, usually. And then the second would be the data privacy principles.
Okay. Maraming salamat, Jam. Oh, by the way, the representative of Pasig City LGU is also in the room. Say hello, Eric Rayos. Now, Jam, before I go to the other advanced questions, just to bring it down na medyo practical. Si Daniel Andea from Borongan City has this question. Does using CBMS data and program policy formulation of the LGU without the consent of individual household violate the Data Privacy Act? So ito medyo, I think this is it's more common na talagang nalilito ang mga LGUs. Hindi lang ayaw nilang i-share yung CBMS data. Nagwo-worry din sila na pag ginamit yon, it could be violative of the DPA. Can you respond to that?
Pwedeng paano ulit yung, ano nga ulit yung acronym na CBMS?
CBMS, Community-Based Monitoring System.
Ayan yung, there was this law, no? Na passed a couple of years ago ba yan?
Yes. Ayan. It just passed and then it's now under PSA na ang gumagawa.
Okay. So, every time may mga question kasi about whether we can use it without asking for consent, parang ganon. Yung questions like this, we only need to break them down into the parang basic components or basic concepts na are introduced to us pag inaaral natin yung Data Privacy Act. So in this case, you have your data subjects which are the citizens, kumbaga, or residents or particular LGU, let's say. And then you have your personal data na nandoon sa CBMS na system. And then you have the personal information controller, which is the LGU. So ang question ngayon is, can the personal information controller process this personal data without asking for the consent of the data subjects? Di ba? Essentially, ganun yung tanong. Once na breakdown na kasi siya sa natin in that manner, mas madali na siyang sagutin. Kasi ang sagot pa rin dyan is, yun nga, ang general rule naman sa Data Privacy Act is that assuming it is covered by the Data Privacy Act, yung personal data or data na pinag-usapan natin, ang general rule dyan is, in order for you to process personal data, it has to have a legal basis under the law. Ngayon, kung sasagutin ko yun, ang questions ko or clarificatory questions ko is, ano ba yung nilalaman ng CBMS? Is it only personal information or do they only contain sensitive personal information? Now, I'm going to assume, let's say may sensitive personal information. Yun. So, our list of options actually is narrowed down. Kasi ngayon, ang sagot na doon sa katanungan is, can the LGU process now the personal data in the CBMS based on any of the grounds in Section 13 of the Data Privacy Act? Yung Section 13 kasi yan yung criteria for the lawful processing of sensitive personal information. Letter A doon is consent. Pero based nga doon sa question, ang premise is without having to ask for the consent. So ang titingnan mo na lang is from letter B to letter F kung hindi ako nagkakamali. Ngayon, if you can find a legal basis for processing that personal data parang from letter B to letter F, then the answer is yes, you can process that personal data without asking for the consent of the individual. For example, ang letter B doon actually is law or regulation. So if there is a law or a regulation saying na you process this personal information, even if sensitive personal information niya, for this purpose, for that purpose, then by all means, process that data in the CBMS for that purpose. Kasi ang basis mo is there is a law or a regulation either requiring you or allowing you to do that. So magiging siyang case-to-case scenario. Doon, sa example ko na yun, if there is a law or regulation. Kung wala law or regulation, tingnan mo yung mga nasa sunod na listahan. Because yun yung magiging answer. If natapos mo yung listahan and then ang conclusion mo is wala ni isa dito ang pwede naming pagbasehan to process personal data, pwede mong i-check sunod yung mga so-called exemptions na nasa sa batas which is found in Section 3 or Section 4. Pero very specific din yung mga exemptions na yun. So tingnan mo if may mag-a-apply doon sa balak mong gawin doon sa personal data. If wala din, so tinignan mo na yung Section 13, tinignan mo yung exemption sa scope, then ang sagot ko na is wala ka talagang choice. You will have to get the consent of the individual. And if hindi mo siya makikita or hindi mo makukuha yung consent, and then you proceed with processing the personal data, then that's the time na you will be considered as violating the Data Privacy Act. So may proseso. If you, ang general rule is find a legal basis. If meron naman, then you can do that without asking for consent.
Okay. Yeah, Jam, when the CBMS is implemented, there's actually a consent form for those who are covered by the CBMS. So kumbaga, when the data is collected from them, may consent sila. So ang tanong na lang nito is ipaprocess. But there's also another thing, di ba? We collect data because we want to use the data. So hindi naman mahirap naman yung every step of the way, collection may consent na. Tapos na-collect mo yung data, ayaw gamitin ng mga LGUs dahil baka nga DPA violation yon. But we don't collect the data just for the heck of it. We collect it because we need this. We use this for policy. We use this for programs. So hindi lang yung CBMS, pati yung halimbawa yung FIES, may sensitive personal information din naman doon eh. But when we use this, when we process this, hindi na naman kasama, hindi na naman lumalabas yung alam mo, the first decile of the of Philippine households have an income of say 5,000 pesos a year, mga ganon. Hindi naman nang sasabihin na that includes my family, which could be the violative of the DPA, di ba? So yun lang. Para lang, I think maybe assure our LGUs, and because this is, the government collects data all the time and processes those data and information to make programs and policies.
Correct. So yun, yung sa consent, critical yun kasi if you say na every time naman nagko-collect, there is consent, then you have to look at kung ano yung sinasabi doon sa consent. What are the people agreeing to? Kasi ang requirement kasi sa Data Privacy Act, the consent has to be specific. Now, I will qualify that in saying na recognized naman sa data protection laws na although consent has to be specific, there are certain types of processing na considered compatible doon sa declared purposes. So meaning, even if you ask for consent in processing personal data for one purpose, and then you end up processing that personal data for compatible purposes, okay pa rin yun. That will be allowed under the law. Ano ba itong mga tinuturing na compatible purposes? Processing for research, scientific and historical research, processing for processing in the form of archiving in the public interest, ano pa ba? Processing in the form for statistical purposes and so on. So itong mga purposes na to, they can be or type of processing na to, they can be performed on personal data collected for other purposes. So yun din siguro ang kailangan kong i-clarify. Na baka din kasi na magkaroon ng impression na yun nga, dahil humingi ng consent and then for this purpose lang siya, then absolutely wala nang pwedeng gawin doon sa personal data na yun na kinolekta. Meron namang kino-consider na parang exemptions or at least permitted processing operations, which is yung nabanggit ko. If you will look at the scope din pati ng Data Privacy Act, one of the exemptions found there is those personal data processed for research purposes. So that's another thing na you can look into to justify why you are using personal data for research purposes, for instance, which is more or less a precursor din sa policy making, di ba? Yun.
Okay, sige. Thank you. Jam, maraming questions dito related to DPO. I-abstract ko na lang ha. So yung isa ay what happens if the LGU is unable to designate a DPO? So yung second part kasi ng question nasagot mo na kanina, is it better to have an IT or legal officer as DPO? But you already said that it might give rise to conflict of interest eventually. So hindi sila yung ideal. Pero kung hindi sila makapag-designate ng DPO, what could happen? And a related question is something that has to do with DPO lang ba ang talagang may sole authority sa pagde-decide ng data privacy concerns, or may committee? You already said that ideally committee din. Pero bakit DPO lang kahit iba naman yung nag-violate ng privacy laws? Bakit DPO yung
iba pa ang question yun. Okay. Isa-isahin ko. Yung una, anong mangyayari if hindi ka nag-appoint ng DPO? Right now, wala namang crime under the Data Privacy Act na nagsasabing failure to appoint a DPO parang is considered, yun nga, punishable by imprisonment or payment of fine, di ba? So, in that regard, safe pa ang LGU or kung sino man yung nagme-make ng decision regarding that. Ang pwedeng mag-give rise though is that kung wala kayong data protection officer guiding the organization, then the commission of all those other crimes na meron actually sa batas, yung risk na magkakaroon ng ganon is tataas. For instance, there is a crime under the law na ang tawag sa kanya is disclosure or access due to negligence. So ibig sabihin, nagkaroon ng unauthorized access sa personal data na hawak-hawak ng LGU, let's say, and ang reason nun is dahil sa kapabayaan ng controller or in that case, the LGU. Kung wala kayong DPO, mas mataas yung likelihood na mayroong ganyan, di ba? So even if directly wala kayong accountability for not appointing a DPO, criminal law for criminal law purposes, kumbaga, pwede siyang magkaroon ng repercussions or implications in relation to all these other crimes. That's for criminal law. Kung pag-uusapan naman natin ang administrative liability, for now, thankfully for everyone, wala din pang schedule of fines na ini-issue ang National Privacy Commission. Kung matatandaan nyo, mid last year, parang naglabas na sila ng draft. Doon, if ma-issue yung schedule of fines na yun, doon kayo magkakaroon ng possible liability for not complying with certain directives or requirements ng NPC, especially if those requirements actually are found in the law. Yung pagkakaroon nga ng DPO, nasa batas, di ba? Even if hindi siya specifically minimension na DPO sa batas, what is in the law is designate an individual or individuals na in charge of ensuring your compliance with the law. Ang ginawa lang naman ng NPC is pinangalanan siya, which is the DPO. So yun,
okay.
yun yung ano. What else? Regarding the decisions, I think nasagot ko na siya kanina in passing when I said na actually ang DPOs are advisory or recommendatory roles. The decision does not rest with the DPOs. The decision remains with whoever is making the decision in the organization or in your case in the LGU. So kung sa amin, sa Ateneo for instance, I don't make the decision. The decision is made by the president. Or kung gusto pang mas mataas na higher authority, the board. So I don't make any decision at all. The most I can do is recommend. So yun, parang yun yung sagot doon sa pagdating sa pagdi-decide. The DPO actually doesn't decide. You study things, you recommend kung ano yung nakikita mong best course of action for a particular issue or particular problem. And then doon naman sa liability ng DPO, which is another question I also saw earlier, ang sagot actually dyan, there is nothing actually in the law that says na the DPO will always be liable if there is a data privacy violation committed within a particular organization. Yung DPO ang makukulong, I think that's a bad joke na that's gone out of hand. Nung NPC pa kami, that's one of the first few jokes I think narinig ko na unfortunately enough, ang nagbigay is mga taga-NPC din. Parang okay lang yun na mag-DPO, sila na yung makukulong, parang ganun. And then apparently maraming nagseryoso sa kanya. Pero actually, if you will look at the law, if the offender is a juridical entity, let's say an LGU, a corporation, and a civil society organization, ang sabi lang naman sa batas is the penalty will be imposed on the individual or individuals who either committed or participated in the commission of the crime or because of their negligence, the crime was committed. So yan yung criteria sa batas. Walang sinasabi na it's the DPO. So posibleng it's your president or your mayor or your sanggunian or kung sino pa man, yung head ng IT or yung legal, kahit sino po pwedeng maging accountable under the DPA. If ang mapatunayan is that there is this crime na listed under the Data Privacy Act, and then itong mga taong ito, either they committed that crime or because of them, all these crimes were committed. Yun.
Okay, sige. Jam, meron dito, hindi lang niya defined kung anong ibig niya sabihin, pero ano daw ba yung penalty for releasing or publishing erroneous data? Parang two levels tong questions na to.
Releasing erroneous data. If we are talking about personal data, kasi yun naman, I suppose, kasi we are talking about data privacy. If it's erroneous data na walang kinalaman sa personal data, then walang penalty whatsoever under the Data Privacy Act because the DPA won't even apply to that. Now, let's say ang pinag-uusapan nga natin is you released or published erroneous or inaccurate personal data of an individual. So wala pa ako so far na encounter na ganito, but if you will look at the law, the closest I suppose na pwede nating i-relate dito is malicious disclosure. So there is a crime called malicious disclosure of personal information or sensitive personal information. But there should be an element of malice in the disclosure. Kasi doon daw sa disclosure, pwedeng correct your information or pwedeng false or inaccurate for that matter, for as long as merong malice, it may be considered a crime under the Data Privacy Act. So yun yung naiisip ko na pinakamalapit dito. And therefore, ang sagot, if it will qualify as that type of offense, then kung ano man yung parang prescribed penalty for that particular offense or crime, then yun yung repercussions. Ngayon, if wala namang malice, and then you released or published erroneous personal data, then I would think ang isang possible liability is baka civil at most siguro. According din kasi sa Data Privacy Act, pwede rin na may right to damages ang data subjects if ever man yung pagpaprocess ng kanilang personal data will lead to harm or injury doon sa data subject. So in this case, if ever the release of erroneous personal data causes harm on the data subject, on the affected data subject, then that could lead to civil liability. Pero kung wala din naman, erroneous nga, pero very minor, and then no effect or impact at all doon sa data subject, then the answer would be no, there would be no penalty.
Jam, I just have like an example in mind, dun sa erroneous. Kasi data or personal information may be erroneous na palabas by one. Either you tamper with it, whoever releases it tampered with it. Yun, liable siya under doon sa you can't change, di ba, personal information. But the other thing is it could be honest error, honest mistake upon the inputting of data, nagkamali, or even those who supply the data, mali yung nabigay nila. So that could also be the thing, and that's why there is possibility for you to have your data corrected, di ba, even under the Data Privacy Act.
Pero yan, all of those things will play out na lang in court. Yung fact na hindi sinasadya, it was an honest mistake, that can be put up as ay parang defense na noong respondent, nung kung sino man yung inakusahan na nag-release ng inaccurate or erroneous data. Tapos isa rin sa pwede niyo pang iput up nga, yun nga, it was an honest mistake, etc. etc. Kung ako naman yung complainant, ang pwede ko naman sabihin is sa Data Privacy Act, one of the principles, data privacy principles is data quality. Ano yung data quality? Na as a controller, it is your responsibility na when you process your personal data, it is complete, it is accurate, and to the extent necessary, it is up to date. Parang ganon. So, ang obligation ko naman as a complainant, kung gusto kong manalo sa kaso, is to emphasize naman na you have that obligation and then you fail to meet that obligation. Para naman doon sa respondent, ang kailangan niya namang ipakita is no, parang perform niya naman yung duties niya, yung obligations niya, and then wala namang harm, etc. etc. So all these things will have to play out na lang kung meron mga magreklamo or magkaso involving supposedly the release or publication of erroneous data.
Jam, again, this is a question about data leaks naman. What if a data leak happens because of the negligence of the DPO or somebody, not necessarily the DPO? What would be the liability?
I think yun na yung sinasabi na banggit ko na kanina, na there is a crime under the law considered access due to negligence. Ewan ko kung pinaparaphrase ko yan, but the essence nga is because there was negligence on the part of the personal information controller, and as a result, nagkaroon ng access doon sa personal data na hawak-hawak niya, then that is considered a crime. Ngayon, if it can be proven na that happened because of the data protection officer, then kung ano man yung, di ko lang memorize kung ilang taon yung imprisonment and then magkano yung fine, but kung ano man yung penalty doon, then yun yung ipapataw sa kanya. But off the top of my head, parang mahirap siyang ma-imagine na yung penalty may impose sa DPO kasi nga, if sinunod nyo naman yung advice na hindi mo dapat ibigay ang position na DPO doon sa mga yung humahawak talaga ng personal data, then hindi ko nakikita paano masasabing kapabayaan niya kung kaya't nagkaroon ng unauthorized access. Pwede siyang mangyari if ang ginawa mong DPO is yung HR head mo or yung ginawa mong DPO is yung sa IT mo, and then yung data breach na nangyari involving information hawak ng HR or information hawak ng IT for that matter. So yun yung nakikita kong instances lang na DPO ang magiging liable.
Okay. Jam, yung next question, ang tingin ko hindi siya privacy, pero I want to ask this dahil to clear din yung mga misconception. Are we obliged to give data to requesters like NGOs asking for our plans for their utilization? What's the penalty for not sharing data being requested? I feel this is FOI, but go ahead, please respond to this.
Kung sa konteksto ng Data Privacy Act, wala namang nakasaad sa batas na you are obliged. Kasi pag sinabi yung obliged, parang so may obligation. And what creates obligation? Usually it's law, di ba? So if ang question is meron bang legal obligation ang LGUs for that matter to disclose personal data to the public, or in this case to NGOs, except doon sa konteksto ng FOI mechanism nga, parang wala naman supposedly legal obligation. So ang papasok ngayon yung magkakaroon ka ng liability, for instance, is if pasok nga siya doon sa scheme ng FOI. Kaso ngayon, ang meron tayong FOI is with the executive department. So kung ano yung sakop ng EO 1 ba yun or number 2 ni the current administration. Kaso nung tingnan ko kasi doon yung probation on ano yung penalties or pag hindi nag-comply doon sa provisions ng batas. Napaka-general kasi ng statement doon, which is parang kung ano man yung parang karampatang penalty or parusa based on civil service rules or administrative rules, etc. etc. So apparently, if sakop ka ng isang FOI, nitong FOI system na meron tayo ngayon, which is limited nga dahil hindi siya Republic Act, and then alinsunod naman sa batas, let's say yung request for information, and then hindi naman napapabilang sa exemptions yung hinihinging information, and for one reason or another, ayon yung i-disclose yung information, then according to that EO, there will be consequences. Pero kung yung basis lang kasi yung EO, hindi niya ni-specify exactly kung ano yung explicit or exact penalties na tinutukoy niya. So kailangan pa nating mag-refer to existing civil service rules to find out ano exactly, parang serious misconduct ba yan, etc. etc. So wala doon sa EO. Pero supposedly meron. And then, ayan, yun na palang sagot din dito sa penalty for not sharing.
Also here, ang parang hindi naman personal information yung hinihingi plans. So if they ask for budget, yung PPAs ng local government, because those are not personal, those don't contain sensitive personal information, they're not covered by the Data Privacy
Act.
Correct. So ang ano lang natin sa Arteche partners and other LGU partners, hindi po under the Data Privacy, you might not be liable kung hindi kayo wala kayong obligation, wala rin kayong liability, but doon sa FOI naman, doon sa ating right to access information, doon kayo pwedeng singilin. Although yung EO number 2 only covers the executive branch, some LGUs have ordinances on FOI, and there are also department memos on related to transparency that you will have to comply with, right? And of course, there's a constitutional guarantee, there's a constitutional right to information. So, pwede ho kayong mabulin doon. So, ang ano natin, unless it's really covered by any exceptions, release it, right? I'm gonna release the information. Tatanong lang, yung DPA ba, does it cover firms and businesses and sensitive information about them? So, how do we distinguish? Kasi pag firms na, etc., pero DPA is actually talking about personal information.
Yes. As a general rule, no. So, unless it's a one-person corporation or a sole proprietorship, which necessarily means the information about the corporation or information about the business would automatically be or maybe classified as personal data kasi parang yun nga, the corporation or the sole proprietorship, the business, is the individual. So except in those rare instances, ang rule is that information about businesses, corporations, any juridical entity is not covered by the Data Privacy Act. Kung tamang alala ko, pati nga BIR na tanong to nung part pa ako ng NPC. Tinanong nila kami kung covered din daw ba yung, let's say, mga tax liabilities ng specific corporations. So sabi namin, because it's information about organizations, juridical entities, then it's not covered by the Data Privacy Act.
Sige, salamat. Unfortunately, we'll have to end the Q&A part. Pero habol lang kasi ito specific example din. Counted ba as sensitive info ang beneficiary list na usually hinihingi in the context of aid delivery and DRR? And related to that, kasdugtong pa rin ng CBMS kasi ginagamit ang CBMS to identify the households that will be given aid or ayuda. So, yun, ano yung relationship niya sa DP?
Yung beneficiaries, parang it's a tricky one because there is a provision actually in the law, nandoon siya sa exemptions from the Data Privacy Act, kung saan daw any parang benefit parang given to you by the government of a pecuniary nature, parang supposedly is exempt from the scope of the Data Privacy Act. Nandoon yan, kung hanapin niyo yung batas, nandoon yan sa one of the exemptions. So if you will read that, it could be interpreted to say na if beneficiary ka of any program ng government na parang pag sinabi kasi natin pecuniary, parang more or less in a financial nature, at least ma-measure mo financially or in terms of money, di ba? Parang ganun. Pwede mo siyang interpret na, so kung hindi siya sakop ng Data Privacy Act, then pwede mo actually siyang i-disclose or at least i-disclose mo in a manner na hindi mo kailangang isipin yung Data Privacy Act. Now, it is possible, pero as parang the privacy advocate and even as part of the National Privacy Commission, ang sinasabi namin dyan is you can do that, pero the safer approach pa rin is to apply pa rin yung data privacy principles when you make that disclosure. Kasi if you will read itong sinigurado namin doon sa implementing rules, dapat even if it's one of those so-called exemptions, the exemption is only limited to the minimum parang extent necessary to achieve kung ano man yung purpose ng processing na balak mong gawin. So for example, ang gusto mong gawin is to disclose the beneficiaries, let's say, parang of a particular government program. Let's say yung 3Ps, parang ganun. Ang sagot is, tapos sasabihin mo, this should not be covered by the Data Privacy Act kasi nga, because of that particular provision na binabanggit ko. Pero ang sasabihin namin is, okay, so you can disclose that, pero ano yung balak mong gawin for the or sino yung pinaka-intended mo talagang recipient of that information? And bakit mo siya gustong i-disclose? Do you want to disclose it parang just for the heck of it? Or do you want to disclose it para to allow other entities, maybe third parties, to audit or to check kung kumusta yung para kung successful ba yung isang government program, etc., etc. Kasi if it's the latter, kung yan yung purpose mo, then from the NPC or from a privacy advocate perspective, ang sasabihin namin is, then limit the disclosure to those people or organizations or government agencies who will make use of that information. Ang sasabihin namin, don't disclose to the public if ang intended beneficiary mo naman pala is just this select group of entities, organizations, or people. Parang ganon. Yan yung parang in keeping with the data privacy principles na sinasabi namin.
Okay, sige. Maraming salamat, Jam. So, I will have to end the open forum at this point. Maraming salamat sa inyong pakikinig. Maraming salamat also, Jam, for answering the questions. We will still pass to Jam the questions that you have para meron tayo namang documented answers afterwards. So I hope you are all ready to answer the post-test later. Again, ito po yung magiging basihan natin ng pag-i-issue ng e-certificates of participation. Well, a lot of you expressed concerns about what guidelines to follow in making data privacy policies or whether there are standard policies and procedures on data privacy implementation that your LGU can adapt. As Jam said, wala ni isa mang LGU na implementa natin nung data privacy checklist ang masasabing merong buo na sistema. So to help you with these concerns, at least an initial step, we would like to show what our Policy Development Lab has prepared, the Data Privacy Manual template, which contains details on the LGU's obligations and the rights of the data subjects pursuant to the data privacy law. To further explain this manual, I would like to call on the Policy Lab lead of COLLABDev, Dr. Shelo Magno.
Thank you, Joy. I will just quickly share my screen. I think isa ito sa mga nalista ni Jam kanina na gap at importanteng bahagi ng ating data privacy. And the main question is, why do we need? What is the purpose of the data privacy manual? So ang purpose ng manual na to ay isang internal guideline ng isang organisasyon, in our context, the local government unit, na kung saan nakalista or naka-enumerate yung mga reasonable and appropriate measures to protect personal data against natural dangers, and at the same time, unlawful access, fraudulent misuse, unlawful destruction, alteration, and contamination. So it also informs the personnel of the LGU on that measure, and each personal information controller and or personal information processor on what is expected in the privacy manual. So yung privacy manual po na dinraft natin, 27 pages po ito, at dinraft natin ito ayon sa advisory ng National Privacy Commission, at ito po ay consistent din with our implementing rules and regulation. Ito po yung outline ng manual natin. So more or less yung mga binanggit ni Jam ay tinatamaan na ng ating manual. So mayroon po itong introduction is explaining the purpose of the manual for your organization or the LGU, the various definition of terms na napakahalagang binabanggit doon sa manual. Meron din pong provision on the scope and limitations, process, guides and steps on processing personal data, ano yung ating mga security measures, ano yung mga responses, mga action, responsibilities kapag nagkaroon ng breach, and the security incidents. At yung binanggit po ni Jam kanina na napakahalaga, recognizing the rights of individuals, na kung saan kinolekta natin yung mga informasyon, mahalagang may grievance mechanism to be able for them to exercise their rights and for us to respond to their inquiries and concerns. So yun po yung outline ng ating manual na maaari naming ipahiram sa inyo. At kakabit din po nung manual na yon ay meron din tayong dinraft na Freedom of Information Ordinance at saka yung kakambal na Data Quality and Management Ordinance. Dito po sa Data Quality and Management ordinance naman natin ay dinidefine natin yung structure, yung mga responsibilities ng DPO, to the extent of creating an office, yung mga policies and processes kung paano natin i-maintain yung data natin, saan natin to i-store, etc. etc. So kumbaga yung tatlong po ito ay triplets or kambal na policies na maaari naming ipahiram sa inyo, ibigay sa inyo, at siguro po ay magpa-parallel meeting na lang tayo kung paano natin iti-tailor yung 3 policies na ito given sa context ng LGU. Yun po, maraming salamat.
Maraming salamat, Shelo, and maraming salamat ang bilis ng presentation mo, pero malaman naman. So, thank you sa efforts ng Policy Development Lab. Ito pong DPA manual, as sinabi nga ni Doc Shelo, ay kasama ng iba pang mga pulisiya na imumungkahi natin na i-adapt sana ng mga LGUs. Of course, kasama dyan yung pagbibigay din sa inyo ng kadagdagang kaalaman para ma-implement nyo ang mga ito. Okay, so finally, to wrap up this session, let me call on the coordinator of the Data-Driven Development or the 3D Program of Action for Economic Reforms and the data lead of the COLLABDev and PH3D project. So, Dr. Lawrence Go. Hi, Lawrence. He's here to give the closing remarks.
Yeah. Hi, Ma'am Joy. Ayun. So, as we've seen, so today we've learned how data privacy can be very complex, but also a very important part of managing our data systems in the LGU. So, the reason that we organized this event, especially for our partners, is that we recognize how, despite its importance, yung implementation po ng law is still in its very early stages. So as Attorney Jam mentioned, yun nga, parang karamihan po, marami pa pong lagging behind, but that's okay. And so we hope that through this event, we can actually start to think about how to establish our data privacy practice, while also appreciating yung significance of data when we make decisions in our local government. So if today's event has piqued your interest in data privacy, I'd like to invite you to watch out for our third module sa Pride platform on data governance, which actually also includes Attorney Jam's lecture on data privacy. We also have FOI and other data governance modules. So of course, I'd like to thank our speakers, Attorney Jam, for showing us the way to implementing data privacy in our LGUs. And as always, we appreciate our partners for their presence and active participation in our events. So there are so many more activities to look forward to this year. Meron pa po tayong capacity building activities for our data focus on using Google Drive as cloud storage, and also Kobo Toolbox for online data collection. We also look forward to seeing you all sa lahat ng events natin that the Data Lab is organizing, but also those of COLLABDev and PH3D in general. So, yun. Maraming salamat po, Ma'am Joy.
Okay, maraming salamat, Lawrence. So, antabayanan niyo po yung lahat ng mga activities na yon, at marami pa po tayong nakahilera o kaya nakahanay na mga gagawin dito sa Data-Driven Development Program ng AER, both sa COLLABDev and sa PH3D project. So, this is our contribution to our partners who want to really develop and enhance your data governance. So before we end, we would like to invite everyone to please answer the post test we prepared for you to assess how this session has helped increase your awareness of the data privacy law and practice in local government. We will be sending e-certificates of participation based on both the registration and this poll, your responses. So please don't forget to answer the poll now. It's flash on your screen. Makikita nyo po na nakalagay dyan. And I think Tat or Nadine will also be posting the link to the poll kung hindi nyo na, kung nawala na sa inyo. And then after the program, we will also be sending a link to your email that you use for your registration para sakaling hindi na kayo nakahabol. While you're answering the post test, we would also like to encourage everyone to visit the AER's Data-Driven Development Project social media accounts. For COLLABDev, meron po tayong website, collabdev.aer.ph, where you can find news and events, stories, policy notes, and other resources on data-driven development. Kindly follow us also on our Facebook page and subscribe to our YouTube channel, yung Action for Economic Reforms po. We have also created a COLLABDev Facebook group for the members of the Data for Dev Coalition and for our partners and friends doing 3D work in the Philippines. This is our safe space to share our stories and updates from the ground, and a venue where we can interact and stay connected. So if you wish to be part of it, kindly search COLLABDev and ask to join sa Facebook. Or you may inform your local coordinator so that they can invite you. Ang PH3D po, may website din. It's ph3d.aer.ph, and it contains everything that you need to know about the PH3D project. They also release data-related learning discussions on their YouTube channel, and you may find and subscribe to their channel by searching AER PH3D. So you may click on the link na po posted on your Zoom box, and kung yung poll ay nandito pa rin sa screen niyo, please accomplish that now. Okay? Finally, we will be having our Pride training on data governance. Nabanggit na to ni Lawrence kanina, and data security soon. So watch out for that. For COLLABDev, we will have the interaction with resource speakers of course 2A on data literacy on Thursday, February 24, 1 to 2 p.m. Magkita-kita po tayo lahat sa WebEx. Okay na ba tayo? I hope everyone is done answering. Yeah, so again, thank you very much for joining us. May I request all of you to please turn on your camera for the group photo. Magre-request lang po tayo. Ayan, group photo. Who will be taking the photo? Tat, will it be you? You're
yes,
muted.
Po.
Yeah, please be ascent. Yeah.
Okay. Sige po, let us smile on 3 sa first panel po, ha? Sige. Sandali lang. Wait lang po, ha? Ayan, first panel. 1, 2, 3. Okay, sandali lang po. Isa-save lang po yung photo natin. Po, very quickly. Okay po, then sa next panel naman po, please smile, continue smiling, baka nasa lang kayo, kabila. Sige, 1, 2, 3. Okay, thank you po. Maraming salamat.
Okay, maraming salamat, Tat, at maraming salamat po sa inyong lahat. Komplikado, masalimuot ang Data Privacy Act, pero hindi naman po to imposibleng sundin. And we promise you that we will help you navigate the process towards having a good data privacy regime, data protection regime sa LGU ninyo. Of course, as much as we can. And please, if you have further inquiries, hesitate to send us an email dun sa COLLABDev and PH3D accounts natin. Maraming salamat again, Jam. Maraming salamat po sa lahat ng mga LGU partners natin na nandito ngayon for taking time out of your busy schedules. Salamat po. Please stay healthy and well, and please be mindful of protecting and data sensitive personal information, but at the same time, as local government units, as public officials, public servants, we also have a responsibility to share the information that we have to our constituencies. Basta lang po, dapat pangalagaan ang dapat pangalagaan at ipahagi ang dapat ibahagi. So magandang hapon po. Bye-bye. See you on Thursday, and see you. Good luck sa mga Pride sessions po natin.
The lack of quality data and strong partnerships leads to weak policies and programs. As shown during the pandemic, communities without proper evidence and strong coalitions are struggling to adapt and are left behind. How can we harness the power of data and coalitions to drive development? Introducing COLLABDev, Coalescing Organizations Towards Locally Led Actions to Boost Development, a partnership between Action for Economic Reforms and the United States Agency for International Development. COLLABDev promotes human-centered, data-driven development in the Philippines. We believe that by strengthening local coalitions and enhancing data capacities, local actors will have increased power to improve their own communities. This is done by first collecting data that is timely, disaggregated, holistic, and involves local actors to identify priorities. Second, ensuring data is accessible to all stakeholders, LGUs, academia, CSOs, and the public. Third, analyzing data to become valuable information, evidence, and knowledge. Fourth, using the evidence produced as the basis for creating policies and programs. Finally, through regular feedback, this process will lead to improved prioritization, mobilization, and allocation of local resources for human development. Enabling this process are the use of state-of-the-art technology and formation of strong partnerships. At COLLABDev, our efforts are broadly grouped into three components. Development Data Lab is in charge of the Data to Evidence initiative. Policy Development Lab leads the Evidence to Policy and Policy to Development initiatives. And Data and Tech Alliance for Development will create local coalitions and coordinate with other collaborators for stronger partnerships. COLLABDev will run from January 2021 to June 2023 in 10 areas: Lungsod, Irosin, and Pilar in Sorsogon, Inupacan, Tanawan, and Tolosa in Leyte, Borongan City and Salcedo in Eastern Samar, Cagayan de Oro City in Misamis Oriental, and Palimbang in Sultan Kudarat.
At its core, COLLABDev is about harnessing the power of data and technology to deliver evidence-based solutions.
In order to achieve this goal, building and sustaining strong coalitions is essential to everything we do.
We work hand in hand with partners from the local government, the academe, and the civil society organizations.
Together, we seek to instill a culture of data appreciation among partners and the wider public.
Let's work together
for a human-centered,
data-driven, and participatory development.
Collaborate with COLLABDev.